Hello friends, this is Dr. Devaruti Haldar. I am the Honorary Managing Director for Center for Cyber Victim Counseling. In this video, I am going to speak about hacking and how this has been dealt with under the Indian laws, that is Information Technology Act 2000, which has been amended in 2008. I have seen many victims, students of law, and many persons who get confused between the term hacking and cyberbullying, cyber trolling, creation, distribution, production, etc. of sexually explicit content, cyber obscenity, child pornography, etc. Before we begin discussion on hacking, we need to understand that hacking is not synonymous to cyberbullying or trolling or creation, distribution, production, etc. of sexually explicit content or obscenity or child pornographic materials or voyeurism, etc. Even though the act of hacking may be used to create such contents or for spreading such contents, but basically these concepts are different. Now, it is very interesting to note that the term hacking has not been used by the laws in India. Section 43 of the Information Technology Act 2000, amended in 2003, addresses compensation for damage to the computer, etc. This is the section, or this is the legal provision which actually deals with hacking by way of explaining it as unauthorized access to the data, computer resources, etc. This also includes, that means this kind of offense also includes damaging the data, stealing the data, unauthorizedly changing the data after accessing the data or the computer resources, unauthorizedly downloading the data, or even, for example, contaminating the computer data or computer resources, etc., which actually means injecting the data or the computer resources with some kinds of virus, denial of service, dedicated denial of services, or even attempting to commit such offense or helping any other person who wants to unauthorizedly access the data, computer resources, etc. Very briefly, this actually means privacy infringement, or rather digital privacy infringement. Now, Section 43 actually is a civil offense because under the IT Act 2000, amended in 2008, there can be two kinds of offenses, and hacking or unauthorized access to the computer resources, data, etc. They can be considered, or this can be considered, both under the civil offenses as well as under the criminal offenses. If this is considered as civil offense, Section 43 will be applicable, and it would be dealt with by the adjudicator. Now, what can be the compensation for such kinds of unauthorized access, damage to the computer resources, etc.? Section 43 does not specifically mention about the amount of compensation. However, erstwhile, 1 crore rupees was held to be the ceiling of compensation for these kinds of damage to the computer resource, data, etc. Presently, Section 45 may also need to be looked into because Section 45 speaks about residuary penalty. Also, the adjudicator may decide about the compensation amount depending upon the defamation that may have been caused because of the unauthorized access to the data, damage to the computer, etc., or because of the financial harm that may have been caused because of such kinds of data, unauthorized access to the data, damage to the computer, etc. However, if this data was being stored by any body corporate, that is any company, and because of the negligence of this company, the data has been unauthorizedly accessed, etc., and such data is actually in the nature of sensitive personal information, then the body corporate will be held liable, and the body corporate, by virtue of Section 43A, has to pay a huge compensation to the owner of the data, that is the actual owner of the data. The amount that is shown in Section 43A as compensation is 5 crores, that is the ceiling is 5 crores. However, the general practice shows that it again depends upon the quantity of the data, that is the quantity of the reputation damage, financial harm, etc. And then it also depends upon the adjudicator that how much amount of compensation would be paid by the company to the victim. Now, the unauthorized access to the data, damage to the computer system, denial of services, then illegal downloading of that particular data, changing of the data, etc., by way of unauthorized access to the data, etc., has also been considered as a criminal offense. And this has been dealt with under Section 66, which can also be read with under Section 65. 66 actually speaks about offenses related to the computer, etc., and it indicates the same explanation as has been given under Section 43. However, 66, that is Section 66, prescribes punishment for up to 3 years of imprisonment or with fine or both. If this is considered as a criminal offense, which is most generally that is actually considered as a criminal offense, then the victim can and should take all the materials, evidences to the police, and they can register a complaint to the police. Now, unauthorized access to the data, computer resources, illegal downloading of the data, changing of the data, etc., can actually be used to create morphed photograph, to create defamatory profile of the victims. Also, it can also help in creating sexually explicit content. We all need to understand that Section 67 and 67A has been created, that is Section 67 and 67A of the IT Act 2000, amended in 2008, has been created to deal with sexual explicit content, obscenity, etc. And also Section 67B is actually created for looking after the issues of child pornography, which must also be read with POCSO Act. Now, if this unauthorized access to the computer data, or damage to the data, etc., are or have been used for creation of sexually explicit content or obscene materials, especially because obscene materials are also dealt with by Section 67 and also Section 67A, which deals with the sexually explicit material and obscenity. Now, if these are actually used, I mean, if this method is actually used, then 67 and 67A should be read with Section 66. However, 67 and 67A also prescribes different punishments. So, as per the IT Act and also as per the natural justice, principles of natural justice, the police generally books the offender under that particular provision which prescribes higher punishment. However, if, for example, the social media profile has been hacked or unauthorizedly accessed, or the email ID has been hacked or unauthorizedly accessed, or the devices, that is the computer or computer resources, etc., have been unauthorizedly accessed, or damage has been done to these particular devices or data, etc., to create gross harm to the victim and also to defame the victim, Section 499 read with Section 500 can also be applicable. These are actually from the Indian Penal Code provision. What the victim can do in such cases is that the victim should not get panicked. Irrespective of the gender, the victim can definitely collect the evidences, that is either by taking a screenshot or by taking the device as it is, and go to the police station and file a proper complaint with the help of the evidences that are collected by the victim. Obviously, thereafter, the police, while in the course of the investigation, they would also collect the other evidences. After this, it is always advised to the victim that not to step into the shoes of the perpetrator. That means the victim should not threaten the perpetrator. The victim should not try to again unauthorizedly access the content that has been created by the perpetrator, because at that time the perpetrator may step into the shoes of the victim and can start claiming that the victim has unauthorizedly accessed in the profile or data that is now being possessed by the perpetrator. I hope this can be useful, or this can help general public, also the persons who may have been victimized by way of unauthorized access, hacking, etc., and also the victims who may have been targeted by the perpetrators by creating of morphed pictures or fake profiles, etc. In my next video, I will be again speaking about sexually explicit content, obscenity, etc. And I hope this is going to be useful for all of you. Thank you again.